For years, bringing a husband, a wife, a parent, or a child to the United States has meant one thing: waiting. Waiting 12 months, waiting 18 months, sometimes waiting more than 2 years just for the first approval. And during that time, families have missed birthdays, anniversaries, graduations, even the birth of their own children. Entire chapters of life unfolding across borders. But starting in February 2026, something changes. Not a small tweak, not a minor policy memo buried in a government website. A structural shift in how I-130 petitions are processed. A shift that could cut processing times in half. In some cases, even more. For certain families, what once took well over a year could now take just months. And for others, there may finally be an option to receive a decision in as little as 15 business days. The question is, who benefits the most? What exactly is changing behind the scenes at USCIS? And if you already filed your petition, will you see any advantage at all? Because here's the part most people aren't talking about. Depending on your category, filing strategy, and timing, February 2026 could either accelerate your case dramatically or barely move the needle. And there's one critical decision some families need to make before these changes fully roll out. So, if you're currently separated from someone you love, or you're about to begin the family-based immigration process, what you do next could shape your entire timeline. Let's break down exactly what's happening and what it means for your family. Starting in February 2026, USCIS is implementing major operational changes to how I-130 petitions, the foundation of family immigration, are processed. And if you're a U.S. citizen petitioning for your spouse, your parent, or your unmarried child under 21, or if you're a green card holder sponsoring close family, this could significantly impact your timeline. In this video, I'm going to walk you through exactly what's changing, why these changes are happening now, who stands to benefit the most, what the new processing time projections look like, and most importantly, what specific actions you should take to maximize these improvements for your own case. We'll also talk about premium processing, expedited criteria, and the categories that, unfortunately, may not see dramatic improvements despite the headlines. So stay with me, because by the end of this video, you'll know whether February 2026 is simply good news or a true turning point for your family's immigration journey. To really understand why these February 2026 changes matter so much, we have to step back and look at what the I-130 process has felt like for families over the past several years. The I-130 petition, officially called the Petition for Alien Relative, is the foundation of family-based immigration. It doesn't grant a green card by itself. It doesn't give work authorization. It doesn't allow travel. What it does is establish that a real qualifying family relationship exists between a U.S. citizen or lawful permanent resident and the person they're sponsoring. It's the first domino, and until that domino falls, nothing else can move forward. The problem is that for years, that first step has taken far too long. Depending on the service center, handling the case, and the category of family member, petitioners have routinely waited anywhere from 12 months to over 24 months just for the I-130 approval. And that's before the National Visa Center stage, before consular interviews, before adjustment of status, before background checks. In other words, families were stuck at the starting line for more than a year, sometimes two, without even entering the next phase. Service center inconsistencies made it even more frustrating. One center might process a case in 10 months, while another took 20. Petitioners would check processing times obsessively, compare online forums, refresh their USCIS accounts daily, and still feel powerless. And beyond the numbers, the emotional toll has been enormous. spouses separated across continents trying to maintain a marriage through video calls, children growing up with one parent physically absent, elderly parents aging alone overseas, while their U.S. citizen children waited for paperwork to move. Financial strain from maintaining two households, travel costs, immigration attorney fees, the psychological weight of uncertainty. The backlog wasn't just a bureaucratic issue, it was a human one. A big part of the delay came from a combination of pandemic-era disruptions, staffing shortages, increased filing volumes, and outdated paper-heavy workflows. Even as USCIS recovered operationally, the backlog lingered. Officers were stretched thin. Files moved slowly. Requests for evidence, or RF, added months. And because the I-130 is the gateway to everything else, every delay there multiplied into even longer total separation times. So when we talk about February 2026, we're not talking about a cosmetic improvement. We're talking about a long-aided structural response to a bottleneck that has affected millions of families. Now, before we go deeper into the specific operational changes, if you find these updates helpful and you want ongoing breakdowns of immigration changes that could directly impact your timeline, make sure you're subscribed to the channel and have notifications turned on. Immigration processing isn't static. It shifts sometimes quickly, and staying informed can genuinely make a difference in the decisions you make for your family. So, what exactly changed behind the scenes to allow USCIS to project such significant improvements? The first major piece is staffing, and not just a minor increase. USCIS has expanded its adjudication workforce, specifically targeting family-based petitions. Hundreds of additional officers have been hired and trained with a focused mandate: reduce the I-130 backlog and stabilize processing times moving forward. This matters because immigration case processing is fundamentally a capacity equation. When incoming filings outpace adjudicator output, a backlog builds. When staffing increases beyond intake volume, the agency can finally start shrinking that backlog instead of just maintaining it. But this isn't only about adding more people. It's also about how those officers are deployed. Under the new structure rolling out in February 2026, USCIS is consolidating certain family-based workloads into more specialized units. Instead of general adjudicators juggling multiple petition types, more officers are being assigned specifically to I-130 reviews. Specialization increases speed. When officers review the same petition category repeatedly, pattern recognition improves, documentation review becomes more efficient, and decision consistency increases. That translates into fewer unnecessary delays and more predictable timelines. There's also a redistribution strategy happening across service centers. Historically, some centers have been overwhelmed while others operated more efficiently. The new framework allows cases to be dynamically shifted based on workload capacity, helping prevent regional bottlenecks. In practical terms, that means your case is less likely to get stuck simply because it landed in an overloaded center. The agency has also adjusted internal performance benchmarks, incentivizing faster case resolution while maintaining review standards. And importantly, the hiring surge wasn't temporary. These officers are part of a longer-term staffing model designed to prevent the backlog from rebuilding once it's reduced. Now, staffing alone wouldn't have solved the entire issue. Even with more officers, outdated systems can slow everything down. And that's where the second layer of change comes in. And in many ways, this technological shift is just as significant as the staffing increase. But to understand how that piece fits into the timeline improvements and why it's so critical for reducing RF and speeding internal workflows, we need to look at how cases actually move inside USCIS once they're filed. And that's exactly what we're diving into next. Adding more officers was a major step, but it only solves part of the equation. Because even with more people reviewing cases, if the system they're working inside is slow, paper-heavy, and fragmented, delays still happen. And that's why the second major shift beginning in February 2026, may be just as transformative as the staffing surge. Technology modernization and digital workflow expansion across I-130 processing. For years, one of the hidden bottlenecks inside USCIS has been the way physical files move. Paper submissions had to be scanned, uploaded, sorted, transferred between units, sometimes even physically shipped between service centers. Every handoff created friction. Every manual data entry step created opportunities for delay. And every request for evidence meant another paper cycle restarting the clock. Under the new system, USCIS has significantly expanded digital intake capabilities and centralized electronic case routing for family-based petitions. More I-130 filings are now fully integrated into an internal digital workflow system from day one, allowing officers to review documents in a streamlined dashboard instead of jumping between fragmented systems. This upgrade includes enhanced document recognition tools that assist officers in verifying civil documents, marriage certificates, birth records, and prior immigration filings more efficiently. It does not replace officer judgment, but it reduces administrative review time. Think of it as eliminating repetitive steps so adjudicators can focus on substantive analysis instead of mechanical tasks. That alone can shave meaningful time off average case processing. Another major improvement is internal case tracking transparency. Officers and supervisors can now see real-time case aging metrics within their units, allowing management to redistribute cases proactively before backlogs begin to spike again. In the past, delays often became visible only after months had passed. Now they can be addressed earlier. And for petitioners, online USCIS accounts are becoming more interactive. Upload functionality for certain follow-up documents, especially RF responses, is being expanded and refined. Instead of printing hundreds of pages, mailing them, and waiting for delivery confirmation, petitioners in eligible cases can upload responses directly through their USCIS portal. That alone can save weeks. And this ties directly into one of the most frustrating sources of delay under the old system: requests for evidence. Starting February 2026, USCIS has rolled out clearer initial filing instructions and standardized evidence checklists for I-130 categories. Officers are also being trained to issue more targeted RF when absolutely necessary, specifying exactly what is missing rather than issuing broad, open-ended requests. The goal is simple: reduce unnecessary RF and shorten the response cycle when they do occur, because historically, an RF could easily add 3 to 6 months to a case timeline. Under the new digital response structure, that lag time should shrink considerably, provided the petitioner responds thoroughly and promptly. But as impactful as staffing and technology improvements are, there's one headline change that has captured the most attention. And for many families, it could be the single biggest game changer in this entire update. For years, family-based petitioners watched employment-based applicants benefit from premium processing, a service that guaranteed a decision within 15 business days for an additional fee. Spouses and parents of U.S. citizens had no such option. That changes in February 2026. USCIS is expanding premium processing eligibility to include certain immediate relative I-130 petitions. Specifically, U.S. citizens filing for their spouse, their unmarried child under 21, or their parent, if the petitioner is at least 21 years old, will have the option to request premium processing for the I-130 stage. The fee is set at $20,500, and in exchange, USCIS guarantees a decision within 15 business days. Now, it's very important to understand what that guarantee means. It guarantees a decision, approval, denial, or RF within that time frame. It does not guarantee approval. So, if a petition is incomplete, lacks sufficient relationship evidence, or contains inconsistencies, premium processing will not protect it from denial. But for well-prepared cases, this is extraordinary. Instead of waiting 12 to 18 months for the I-130 approval, families could receive that first crucial approval in about 3 weeks. 3 weeks instead of a year. That dramatically shifts the emotional and logistical landscape for many families. If a U.S. citizen is separated from their spouse overseas, that approval allows the case to move to the National Visa Center stage almost immediately. If the beneficiary is adjusting status inside the United States, the approval allows the I-485 to proceed without prolonged uncertainty tied to the underlying petition. Now, premium processing does not eliminate the National Visa Center timeline. It does not speed up consular interview scheduling. It does not bypass background checks. Those stages still follow their own processes. But shaving a year off the front end of the case can mean reunification happens 12 to 18 months earlier overall for families facing medical urgency, military deployment, expiring work contracts, or prolonged emotional hardship. That difference is enormous. However, premium processing is not automatically the right choice for everyone. The $2,500 fee is substantial. Families need to weigh the financial cost against the time saved. If your case is already well underway and nearing standard approval, upgrading may not make sense. If your category is subject to long visa bulletin backlogs, like siblings or adult children in preference categories, premium processing won't eliminate those multi-year waits. It only accelerates the petition approval itself. And this is where strategy becomes critical. Immediate relatives of U.S. citizens stand to benefit the most because they are not subject to annual visa caps. Once the I-130 is approved, they can move forward without waiting for a priority date to become current. That's why this premium expansion is such a major shift, specifically for spouses, parents, and unmarried minor children of U.S. citizens. We're going to break down exact timeline comparisons shortly, old system versus new system, so you can see how dramatic the difference could be in real numbers. But before we move into those projections, there's another key improvement happening alongside premium processing that affects both standard and expedited cases. And it has to do with how USCIS is prioritizing urgent humanitarian situations under the new framework. Even with faster staffing and premium processing now available for certain categories, one of the biggest silent case killers under the old system was the request for evidence. An RF could take a case that was moving steadily and suddenly freeze it for months. You would receive a notice asking for additional documentation, sometimes specific, sometimes frustratingly vague, and the clock would essentially stop. You'd scramble to gather documents, translations, affidavit, financial records, relationship proof, then mail everything back and wait again for it to be reviewed. And because responses re-entered a processing queue, that temporary pause often stretched into 3, 4, sometimes even 6 additional months. Starting in February 2026, USCIS is making targeted changes designed to reduce both the frequency and the impact of RFS in I-130 cases. First, filing instructions have become more structured and more detailed. Instead of broad evidence guidance, petitioners are being given clearer checklists tailored to specific relationship categories. For example, spousal petitions now emphasize upfront documentation of bona fide marriage indicators, joint financial records, cohabitation proof, shared responsibilities in a more standardized format. Parent-child petitions emphasize documentary clarity around birth certificates, legitimation issues where applicable, and prior marital history documentation. Second, officers are being trained to issue narrower RF when truly necessary. Rather than sending generic requests that ask for additional proof of relationship, the new approach aims to specify exactly what element is insufficient. Is it a missing divorce decree? An unclear translation certification? Incomplete financial evidence. The goal is precision, and precision reduces unnecessary back and forth. Third, and this is significant, expanded electronic RF response capabilities allow petitioners, in eligible cases, to upload their responses directly through their USCIS online account. No printing, no courier tracking, no guessing whether the packet arrived. That alone eliminates weeks of uncertainty. For families trying to move quickly under the new system, especially those using premium processing, responding efficiently to any RF becomes critical. Because remember, premium guarantees a decision within 15 business days. And that decision could be an RF. If you receive one, the faster and more completely you respond, the faster your case resumes movement. But here's the key takeaway. The new faster system rewards well-prepared petitions. If you submit a thin application, assuming speed will carry it through, you could lose the very advantage these reforms are designed to provide. Complete documentation from the start is more important now than ever. Faster adjudication does not mean lighter scrutiny. It means streamlined review of properly documented cases. Now, let's talk about another area where families may see meaningful improvement. Expedited processing for urgent humanitarian circumstances. Expedite requests have always existed, but approval rates historically felt inconsistent and unpredictable. Criteria were broad, evidence standards varied, and outcomes often depended heavily on discretionary judgment. Beginning February 2026, USCIS is standardizing and clarifying expedite eligibility factors for family-based petitions. Cases involving serious medical conditions affecting either the petitioner or beneficiary are receiving more structured evaluation criteria. Military families facing deployment or relocation may qualify for faster handling. Situations involving minor children separated from parents, especially where documented hardship is present, are being prioritized more systematically. There is also clearer recognition of cases involving threats to personal safety, unstable country conditions impacting a specific beneficiary, or other compelling humanitarian concerns. What's different under the new system isn't that expedites are automatic. They are not. It's that the framework for evaluation is more transparent and documentation-driven. If you are requesting expedited handling, you will need strong objective evidence, medical letters from licensed physicians, deployment orders, documented safety threats, or other credible proof supporting urgency. Vague hardship statements are unlikely to succeed, but well-documented cases are expected to see more consistent outcomes than in previous years. And importantly, expedite review and premium processing are not mutually exclusive. In some urgent cases, families may choose premium processing to secure immediate petition approval while simultaneously requesting expedited handling at later stages, such as National Visa Center processing or interview scheduling. Each stage of the immigration process still has its own timeline, but coordinated strategy can shorten overall separation. Now this brings us to the question most families are waiting to hear answered. What do the actual numbers look like under this new framework? How much time could realistically be saved? And which categories will see dramatic improvements versus those that may experience only modest change because of visa bulletin backlogs? Because understanding that distinction is critical before making any filing or premium processing decisions. And that's exactly where we're heading next. Real projected timelines, side-by-side comparisons, and what they mean for your specific situation. So, let's put real numbers on the table, because this is where the February 2026 changes move from hopeful headlines to measurable impact. Under the previous system, immediate relative I-130 petitions, meaning spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens over 21, routinely took anywhere from 12 to 24 months for approval, depending on the service center. Some cases moved faster, many did not, and that approval was only the first step. After that came National Visa Center processing, document review, affidavit of support submission, civil document uploads, and finally interview scheduling at a U.S. consulate abroad, which could add another 9 to 15 months depending on the country. Under the new framework, beginning February 2026, standard processing times for immediate relatives are projected to drop to approximately 6 to 9 months for most cases. That alone cuts the initial wait nearly in half. For families who opt for premium processing, that first stage could shrink to just 15 business days, roughly 3 weeks. Now remember, premium processing accelerates the I-130 adjudication itself. The National Visa Center stage still takes time, typically 6 to 9 months, depending on document readiness and embassy capacity. Interview scheduling timelines also vary by country. But if you remove 12 to 18 months from the front end of the case, overall reunification could happen 1 to 2 years sooner than under the old structure. For immediate relatives, this is transformative because they are not subject to annual visa caps. There is no waiting for a priority date to become current. Once the I-130 is approved and the National Visa Center stage is complete, the case moves directly to interview and visa issuance. That's why these operational changes disproportionately benefit U.S. citizens petitioning for spouses, parents, and minor children. Now let's look at family preference categories. These include unmarried adult children of U.S. citizens, F1, spouses, and unmarried children of lawful permanent residents, F2A, unmarried adult children of lawful permanent residents, F2B, married children of U.S. citizens, F3, and siblings of U.S. citizens, F4. These categories are subject to annual numerical limits, meaning visa availability depends on priority dates published in the monthly visa bulletin. Faster I-130 processing helps establish your priority date sooner, but it does not eliminate multi-year visa backlogs in heavily oversubscribed categories. Under the old system, I-130 approval and preference categories often took 18 to 24 months. Under the new structure, projections suggest 6 to 9 months for most of these petitions as well. That's still meaningful. If your category has a 6-year backlog, shaving 1 year off the petition stage effectively moves you 1 year closer to visa availability. But it does not erase the wait entirely. And this is especially relevant for beneficiaries from countries like Mexico, the Philippines, India, and China, where visa retrogression can significantly extend timelines in certain preference categories. Let's walk through real-world examples to see how this plays out. Imagine Maria, a U.S. citizen living in Texas, petitioning for her husband in Mexico. Under the previous system, she files the I-130 and waits about 16 months for approval. After that, National Visa Center processing takes another 8 months. Interview scheduling in Ciudad Juarez takes an additional 4 months. Total timeline roughly 28 months, sometimes longer. Under the February 2026 system, if Maria uses standard processing and receives approval in 7 months, followed by 8 months at NVC and 4 months to interview, the total drops to around 19 months. That's nearly a year saved. If she chooses premium processing and receives I-30 approval in 15 business days, the total timeline could drop closer to 14 to 16 months overall, cutting separation time nearly in half compared to some historical averages. Now consider John, a lawful permanent resident petitioning for his unmarried adult daughter in the Philippines under the F2B category. Under the previous structure, his I-130 approval might take 20 months. Meanwhile, the visa bulletin backlog for that category and country could stretch 6 to 8 years. Under the new system, John's petition might be approved in 7 months instead. And for many of you watching, February 2026 won't just represent a procedural update. It could represent the beginning of the end of a long separation.